Okay, thank you. I want to make sure that, well, first of all, thank you all for taking the time to log in to this webinar to learn about estate planning, wills, and trust. We have a lot of information for you tonight, and I just want to make sure that everyone can hear me. So at this time, I'm going to do a little bit of explaining about your toolbar that's part of the GoToWebinar process. If you look at your toolbar, you will see that there are a number of different toolbars. You should see one that says chat or questions. If you guys can all see that, go ahead and click the plus sign to the left of questions and just type in yes for me. Thank you, Tony. Janet, Robert, thank you. Okay, great. Looks like we are good. Everyone can hear me. If you have a question, this is how I'm going to be able to see your question. And we do have a particular section for questions towards the end because we do have a lot of information to cover. So if you have a question and you haven't had a chance to ask it yet, please go ahead and type that into the question box and we will get to your questions a little bit towards the end of our webinar. This webinar is going to be recorded, so if you would like to view the webinar later, usually it takes us about 2 business days to get everything onto the system. So if you have a question or you can't remember something that happened in the webinar, it's fine. You'll be able to pause, rewind, fast forward at your leisure. Okay. At this time, direct your attention to your webinar. We're going to be talking about wills and trust. I am one of your presenters. My name is Myra Shelley Kasuk, and I am the Financial Education Coordinator here at LAPFCU. And the reason why we want to talk about wills and trust is because we understand that, you know, because of the nature of your job, we know that protecting your family is extremely crucial. So why should providing security for your loved ones be any different? The National Safety Council estimates that approximately 35,200 people have died in the U.S. due to traffic accidents, with 3.8 million as crash injuries. You know, and so a lot of this, again, can be things that we don't plan for. And if you don't have anything set in place, it can be very hard for your family members once you're gone as well. And so this is just a way of providing security for the people that you love. And again, you'll be able to have your questions answered towards the end of our presentation. At this time, what I would like to do is introduce our next presenter, and this is Richard Napoli. He is the Vice President of Trust and Investments with Members Trust Company. And at this time, I'm going to go ahead and transfer the floor over to Richard. And let's get Richard as a presenter. Okay.
Everything set up, Myra?
Yes. Ready when you are.
All right, everybody. Well, I thank you and appreciate your time. Once again, I'm Richard DiNapoli. I'm a Vice President of Trust and Investments at Members Trust Company, which works exclusively with credit unions throughout the country, including Los Angeles Police Federal Credit Union. And I want to thank Myra for inviting me to speak here tonight. So let's go over the agenda today, or tonight. We're going to give you an overview of Members Trust Company. We're going to talk a little bit about wills, trust basics, commonly used trusts, and also choosing a trustee. And like Myra said, we're going to open the floor to questions. So let me give you a little overview of Members Trust Company. We've been chartered to provide trust services in all 50 states by the Office of Comptroller of the Currency. We're owned by credit unions and their affiliates throughout credit unions all across America. We serve credit union members throughout the country. We've been doing this for the last 27 years. We've got a highly qualified staff of professionals, including attorneys, CFAs, that's Chartered Financial Analysts, CFPs, that's Certified Financial Planners, and then CTFAs, Certified Trust Associates, and so forth. So that's a little bit about Members Trust Company. And as Myra indicated at the beginning of the seminar here, why is estate and incapacity planning important? Well, one is the nature of your career. We know that you put yourselves in the in harm's way to protect the public. So estate planning is especially crucial for officers of the law that put their lives on the line. Also for incapacity planning. And why else is it also important? Because you do want to protect your family. You want to ensure that your wishes are carried out. And you want to try to save your family taxes, try to avoid probate, and intestacy. That we're going to go over very shortly. That is the law of California where you don't have a will. So everything passes according to the laws of intestacy. So we're going to go over that next. So what is a will? Well, we'll start about what not having a will means. Like I said, your assets would pass by the laws of intestacy. You've heard of a last will and testament. So the testament is another word for making your last will. So intestacy means that you don't have a will. And then the state has laws on the books that decide how things go. By not having a will, you're also leaving your guardianship of your minor children. That's also something that the state would decide, as well as who would be your executor. So when you do have a will, you can put that in there, who you want to be a guardian for your minor children, who you want to name as your personal representative, otherwise known as your executor, to make sure that your estate is divided up per your wishes. So does everybody need a will? I'd say yes. I'd say it's very important to have a will because you do want your wishes to be preserved, and you want to try to do everything that you can to help your family, because obviously it's a trying time when somebody passes away, and you want to make it as easy as possible for them. So not having an up-to-date will, you always want to review your will after any major life changes. So one example would be marriage. Another would be divorce, the birth of a child, because you want to reference that child in the will. You also want to talk about guardianship in the event that something happened to you. The death of a spouse or child, so you might have left everything to that spouse or your child, and if something happened to them, you might want to revise your will. Or if you became single, you might want to revise your will so that you can leave your assets to somebody else. Also, a change of residency. When you move from one state to another, different state laws may apply, and you might want to update your will to make sure that it conforms with the laws of that other state. And there's tons of other reasons, for updating your will, just because you might change your mind about who you want to get your assets. But that's all a very personal choice. But always good to keep an up-to-date will. So other important legal documents you may have heard of that typically an attorney will prepare with a will are a power of attorney, a healthcare power of attorney, and a living will. So power of attorney means, you've often also heard of it called a durable power of attorney. That is when you assign somebody else to manage your affairs, primarily your financial affairs, in the event of your incapacity. So if something happened to you, you make decisions on your own, they would make those financial decisions to take care of you for you. And that's who you would name in your power of attorney. Healthcare power of attorney, that's for your healthcare decisions. So you name somebody that you trust to make medical decisions on your behalf in the event that you couldn't make those decisions on your own. And a living will, that's when you decide, primarily a living will is whether or not you want life-sustaining measures taken in the event that you're pretty much towards the end of life. So where they want to use heroic measures to keep you alive, such as feeding tubes, such as, you probably heard tons of cases where somebody's on ventilators and so forth. A lot of people, they don't want that, especially if they're of an advanced age. They want to pass away naturally, and you can put that in what's called a living will. So you would name your wishes there that you don't want any life-sustaining measures taken, and you want to pass away naturally, and that's what you would put in a living will. So some trust basics. So what is a trust? A trust is a separate legal entity. It has its own ownership. It could have its own tax identification number. But typically, when you talk about a living trust, you're oftentimes using the same Social Security number that you have right now, because a living trust is something that you can change while you're alive. And a fiduciary relationship, you've heard the word fiduciary, that means you've entrusted somebody else to manage your affairs, such as your stocks, such as to serve as your personal representative, and they're supposed to look out for you, and that is their priority as a fiduciary. So what are some parties to a trust? Well, you have the grantor. That's the person making the trust. They would be the grantor. The trustee, sometimes the grantor names themselves as the trustee. So me, Richard DiNapoli, I could create a trust and name myself as the trustee while I'm alive. And then I could pick a successor trustee, such as my spouse, to serve after I pass away. And then a beneficiary is the people you would name in that trust to receive your assets. That could be my wife, my children. And then you could also have remainder beneficiaries. So let's say by the time you pass away, you named these people, you didn't update your will in the last final years of your life, and some people that you named had already predeceased you, then that would go on to other beneficiaries. And there can be a whole different set of contingencies as to who might receive what down the line, and those would be the remainder beneficiaries. So who needs a trust? Well, any members with potential estate tax issues. Now, I know the estate tax is pretty high these days, $5.43 million in 2015. So unless you have that much as a single person or over $10 million as a married person, then estate tax would not apply to you if you have less than those amounts. But also a lot of members want to avoid probate. Now you've heard probate as a bad thing. For many smaller estates, it's really not that bad. And a short, what they call a short version of probate can often be done, or many people might not have that many assets in a probate estate. So, but a lot of people do want to avoid probate. They also want to have privacy. When you have a trust, for the most part, whatever you write in there is private, but a will is admitted to the court, and anybody can go down there if they want to and read the entire document. Also, people have a trust when they want to plan for incapacity. So as we talked about earlier, if you ever got in an accident or had a stroke or became ill in some other way and couldn't make decisions on your own, you could name somebody to become your trustee in the event of those things happening. And you could also name somebody in your durable power of attorney and your health care surrogate. Members who want to make provisions for minor children. Well, if you have a trust, then you could state in that trust that, you know, if you were to pass away, and your children were still under the age of, say, 18, you'd want a trust to be set up for them that could be managed by somebody else to provide for them until they reach a certain age, and then possibly to pay them out the principal at that age, or to provide for their health, education, maintenance, or support. And also you have members with unique family needs and issues. We'll get into some more of those as we go on tonight. So let me give you some examples of some commonly used trusts. You've heard earlier the word testament. So a testamentary trust. So a lot of people, they're not familiar with this. This is a trust which is created by a will. So what you do is, in the will, you actually state in your will that you want to give certain assets to certain people, and then you say in that will that upon your death, you want a trust to be created for, say, your minor children. And that's a typical scenario when you have families with minor children. They say that if anything were to happen to both of them, or even one of them, then they want certain monies to be set aside in a trust to be created at their death for the benefit of the children. And so it's not a trust currently created, it's only created in the event of death. And that's very frequent that you'd want to have one of those when you have young children, minor children, or even young adult children that you don't think are financially sophisticated yet, you might want to have a trust set up to manage assets for them until they reach a certain age. So a spendthrift trust is another type of trust you might have heard of. That's typically where you say that assets can only be expended in the trust for, say, health, education, maintenance, or support. And this would be typical where you have a relative or a child, and God forbid, is a substance abuser, gambling addicts, spendthrifts. You want somebody to be looking out so that they don't burn through the money really fast. And you want to make sure that the money is there to last throughout their lifetime possibly, or until they reach certain goal points, such as getting off drugs, taking care of their problems, or changing their lives. And you would set aside that money to help them in that regard. Another type of trust, which is more prevalent these days, is what they call a Q-tip trust. That's frequently used with blended families, and that's where you have an income beneficiary during life and then a remainder beneficiary. So let's say one spouse had children from a prior marriage, but got remarried. And so they might say that if anything happened to them and they passed away, they would want their current spouse to be their income beneficiary of their assets. So the assets would be invested in the market or so forth. And the income from those assets would then go towards providing for the life of their current spouse. And then when that spouse passed away, it would go to their children from a prior marriage. Those would be the remainder beneficiaries. So that's an example of a Q-tip trust for people typically with blended families. And also another example on the next slide here would be a special needs trust. That's where you have members of your family that you want to provide for, but you still want them to qualify for Medicaid and SSI. This is a very special field of the law, so you want to get with an attorney that has experience in setting up a special needs trust. It could also be for children with disabilities and so forth. That's typically where you see this, where you have any children that have disabilities in their life, but you want to set aside some money, but you also want them to be able to qualify for government assistance. So that's what they call a special needs trust. And then the most prevalent trust pretty much of all is a revocable living trust. That has tons of flexibility because it is revocable during life. That's why they call it revocable living trust. It does avoid probate. So what you do is you create the trust, you put assets inside the trust. It could be your home, it could be your stock portfolio, and then those assets pass per the terms of that trust. So it doesn't have to go through probate at the court. It's also great for incapacity planning. You could name a successor trustee, like we talked about earlier, to step into the trustee role in the event that you become incapacitated. It's a core estate planning document. You can change it anytime while you're alive and while you have maintained your faculties, of course, and that's where you can change it, and then it becomes irrevocable only upon death. So as we talked about earlier, there's the federal state tax levels. The threshold has varied significantly in recent years. Starting in 2003, the value started going up from $1 million, and it kept growing and growing and growing. And right now, it's a little bit over $5 million. And it's indexed for inflation. So every year, it keeps getting higher as long as inflation increases. So for 2015, it's actually going to be $5.43 million per person. And it is portable. That means that, if one spouse didn't use it, there's documents that you could file that it transfers over to the other spouse. So for a married couple, you're talking over $10 million in estate value before you have to worry about paying any estate taxes, which run at about 40%. A credit shelter trust, that's what you set up typically when you wanted to take care of planning for the estate tax. It's also known as a bypass trust or family trust. That's used by families, as we said, with potential estate tax issues. Basically, they split their assets so that each member would take care of their own estate tax portion. Each spouse would have the $5 million, another $5 million, and then the assets would grow thereon after their deaths, estate tax free. And right now, you can actually have a portable feature. So if they had all their assets together, one could use their estate tax exemption and apply it to the other one. But you still see credit shelter trusts, also known as bypass trusts or family trusts. They're still very prevalent out there. And you've also referred to them as A-B trusts. So you have Trust A, Trust B. One could be for, as they say, their family to go on for generations, and one could be for the spouse. The assets can be used for that spouse after the first one passes away. So that's a credit shelter trust. So choosing a trustee is also a very important topic. The discussion usually centers around whether to choose a corporate trustee or an individual. And the issues that come into play there are going to be family dynamics. Say you have a large family. You have 2 or 3 sons or daughters, and you and your spouse. So if you were to choose one of those sons or daughters, that may cause some problems down the road where they say, well, why did this person get the choice? Why did this person be designated as the sole trustee? So sometimes it's better to have a corporate trustee because they're going to have that impartiality. They're not going to be involved in the family dynamic as much. They're also going to have a continuity of service. You would engage them while you're alive. They would learn about your wishes. They would learn about your investment portfolio and so forth, and that once you pass away, they are very understanding about what your wishes were. They know how your investment style was, and you would have that continuity of service. Also, they have administrative expertise. One thing when you name an individual as a trustee, if they don't have experience with serving as trustee, it may be a whole new world to them, and they're probably going to go off and engage the advice of a corporate trustee possibly, or they might engage the advice of people that might not know very much about investments, and that's where a lot of trusts can lose a lot of money if the trustee isn't familiar with investing and so forth. So you're going to have that investment management expertise typically with a corporate trustee. And corporate trustees are regulated entities. They do have access to resources such as research and so forth. So that's the difference. Sometimes you have a, you want to always name, a lot of people want to name their spouse as their successor trustee. That's great. You can also name co-trustees, where 2 trustees serve at the same time. One could be a spouse, and one could be a corporate trustee to advise them. Now, one topic, very typical, very important for people that have large IRA assets as their primary source of wealth in retirement, is what we call the trusteed IRA. Now, this is just a document that Members Trust has, and it can be customized. And what it is a customized beneficiary designation where you can restrict beneficiary payout options. So like we talked about with the Spendthrift Trust earlier, you could say, well, I want to leave my IRA assets, an inherited IRA, to my son, but I want to restrict the payouts beyond the required minimum distributions to only health, education, maintenance, or support for such and such time, or until such and such situation occurs. Also important for the blended family, because you could say pretty much the same thing. I want income to my spouse after I pass away, and then I want the remainders to be my children from a prior marriage. So this is something that can be created by just housing the IRA at, say, Members Trust, and then we prepare that customized beneficiary designation form. And you do not need to have a separate IRA trust set up by an attorney when you use the trusteed IRA. So typically you find it very useful for members that have under $1 million in assets, and most of those assets would be in the trusteed IRA. that's where you would have what they call the sweet spot of that circumstance. Typically, people with more than $1 million, they might want to go the attorney route and have a very specialized IRA trust created. But the trust deed IRA enables you to have some customized beneficiary restrictions put into place just on your IRA assets without having to set up a separate, what they call conduit trust. Then a little bit about Members Trust Company. We were named in Forbes in 2008 as one of the top performers for a managed ETF portfolio. That's exchange-traded funds. That's funds that follow an index, and this is for the income one. And so an example of when they talk about income, conservative, balanced, moderate growth, and growth, typically is a function of how much you have in equity, that would be stocks, and then how much you have in fixed income, such as bonds. So income portfolio is going to be more bond-focused, and then a growth portfolio on the other extreme would be more stock-focused, so upwards of 90%. And this is just an example of our conservative fund, and what the breakdown is. You'll see on the left side the fund names. They start out with iShares. Those are indexes that track different bond markets and things such as that. And that's just an explanation of what is in that conservative portfolio. So you'd have some bonds, you'd have some stocks like the S&P 500, the Vanguard Value, and so forth. So the next step, when you're talking about estate planning, when you're talking about trusts, when you're talking about wills, is to review your current plan, if you have one. Always good to keep it up to date. And a lot of members, they haven't looked at it in years. It's typically something that people get, and then they leave it in the safe deposit box, leave it in a drawer, and don't look at it for a long period of time. Always good to review it every so often, review your current estate plan. And we would be glad to help you and help you get in touch with people to update or revise it if necessary. So that's typically something that you got to keep on top of every few years, or if those major life events occur that we talked about earlier. So now I'm going to ask Myra to open the floor to questions, and be happy to talk to you and answer any questions you might have.
Thanks, Richard. We do have a question from James Effort. His question is, I have a trust. Do I also need a will?
Typically, when you have a trust, the attorney would have prepared the will, and it's called a pour-over will, at the same time that he created that trust. And what the pour-over will says is that anything that's not titled in the trust then goes into the trust at your death. So typically, if you went out and got a trust, they would have already prepared that pour-over will for you. So, but you could check, and you'll probably see it in your file there, that there is a last will and testament. It's probably only a couple pages long because it would be a shorter document, and then it would leave everything to your trust that wasn't already in the trust. And the reason why they do that is because you might have an automobile, you might have jewelry, you might have other things, and you want that to pass according to the terms of the trust, but it might be impossible to title those items in a trust. So that's why they call it a pour-over trust. It affects anything that's not titled in the trust, but it does have to go through probate. So everybody kind of has a small probate estate when they pass away. So you don't ever totally avoid probate, but you can do your best to make sure that your major assets and so forth are titled in the trust, and that's where you want the majority of your assets to go if you go the trust route.
Your next question comes from Janet Mullen, and her question is, what is the average cost of preparing a will or trust?
For a will, typically it's going to be like under $1,000. I've seen them as low as $400 or $500. Trust, typically you're going to start at the 1,000 figure, and depending on how complex you get, it can go up from there. I've seen some go up into the thousands, 2,500, 3,000, 4,000, but it depends on how complex your estate is, and also what type of trust you need. So when we talked about special needs, say you have a special needs child, you had to set up one of those. Say you wanted a revocable living trust, and you had very complex wishes and how you wanted to leave things. Some attorneys, they might charge a flat fee. Some might charge an hourly rate. So usually it depends on how complex you want to get. But the will is typically always going to be cheaper. And most of the time, I'd say 99% of the time, an attorney, if they are preparing a will for you, will also give you, with that will, they will offer the durable power of attorney, the living will, and the healthcare surrogate, because those are the core estate planning documents.
Your next question is a little similar to the last one, but you can probably go over it a little bit more. It comes from Daniel and Joan Nee. How much does it cost to set up a revocable living trust for a husband and wife?
Pretty much the same answer. You're gonna start in the 1,000 range. It could be a little bit more, depending on where you live and so forth. So I'd say it's starting in the 1,000 area, 1,500. Some attorneys, they might charge a separate fee for each spouse. So you might be looking at $2,000. It could be $1,000 for each. So you always want to interview a couple of attorneys, and I know that Los Angeles Police, Federal Credit Union, and Members Trust can provide a list of attorneys in that area.
Thank you. Your next question comes from Tracy Edwards. If I set up a trust with a lawyer that is no longer doing business, what can I do to update my trust?
Well, you could get with another lawyer and do what they call an amendment to the trust if you needed to update it. Say you had an attorney that retired. If there's any contact with the attorney, you could ask the attorney that prepared it before if they left their practice to another attorney, and then you can get with the new one. But typically, you could amend it for a lot less money than creating a whole new one. So you'd want to ask your new attorney if you can amend the trust. Now, if it's exceedingly old, they might recommend that you just do a whole new one, and then they might charge you the standard rate. But you should probably ask if you can get away with just doing an amendment to the original trust. Let's say you just wanted to change a beneficiary from, one child to another child because the one was very successful and didn't need any help after you pass away. And so not for any loss of love, but because they have assets of their own, you might want to leave more to one than the other. And that would be a simple change in a trust. Now, if you wanted to revise the entire thing, then most attorneys would just say, hey, we're just going to go and create a whole new one.
Okay, thank you. The next question comes from Tony Tomasella. Should you include all life insurance and 401k accounts?
Well, you should always make sure they're properly titled, that you have the beneficiaries that you want on those accounts, because oftentimes when you're talking life insurance, it's going to pass to the beneficiary. And most of the time, people want that to pass outside of probate, so they just name a beneficiary, and then they get all of it immediately. Now, if you absolutely didn't want somebody to get the entire amount of proceeds, then you'd have to leave that policy to a trust, and then it would be subject to the terms of that trust when you leave it to it. So a lot of times, most people, they just want to have an outright beneficiary. Let's say you have a husband and wife, and the husband has a life insurance policy. They just want the wife to get all the money right away, so that's what they do. And they make sure that you name the spouse in the actual life insurance policy as a beneficiary. But it's up to you if you wanted to name a trust, but most people, they don't want it to pass through any probate or anything. And when you name in your retirement accounts, they pass outside of probate as long as you name somebody, a beneficiary, a living person in those documents. They will pass outside of probate by what they call operation of law. Just like when you leave a house, if it's joint tenants with right of survivorship, it will go to the other person after the first one passes away. So if it's a husband and wife and the husband passes away, the wife will just get the house automatically without having to go through probate and so forth.
Thank you. Your next question comes from Leslie Hills. Does the blended family situation go in order of current spouse and their children, then children of previous marriage?
What was the first part of the question again?
Does the blended family situation go in order of current
the blended
spouse?
family. Oh.
Yes.
You can make it however you want, but you always let's say you have spouse married to current spouse, and then they want to leave assets to their children from the prior marriage. That's their choice. That's why they would go the route of what they call the Q-tip trust, and that's why they would name in a trustee IRA. They could put that beneficiary designation, but there's no requirement that they do. That's just an option that I talked about for people that have those children from the prior marriage. But it's totally their choice if they wanted to do that.
Okay. Your next question comes from Robert Aguilar. Is it necessary to include all bank accounts when you already have beneficiaries named on those accounts?
You mean in a will?
Let's
I
see.
guess we can't ask back the question. But, yeah, in a will, you can just say that you want X amount to go to one person, X amount to go to another. But if you name them as a payable on death beneficiary for each account, that person that you name will automatically get it, and it won't have anything to do with what the will says. So if you have 10 different accounts and you name 10 different people, each one of those persons is going to get one of those accounts automatically by operation of law, not according to your will, not according to a trust, if it's not titled in the trust. It's all going to go according to what that payable on death beneficiary, whoever that is. So you always got to be careful when you're creating a will to also review all of your life insurance accounts, all of your banking accounts, your retirement accounts. You know, there's lots of horror stories out there where people don't realize that they have an ex-spouse that's still on some of those accounts, and they just never looked at they just never reviewed them after they got remarried or after they got divorced. And sometimes the former spouse ends up getting quite a bit of money when their former spouse passes away years later because they didn't update those beneficiary designations. So always important to review those whenever you're talking about estate planning.
Okay, this next question is from Adrian Koval. I have a life insurance through the military. Instead of designating a beneficiary, it was suggested I write down by law. I understand it goes down the line, wife, son, and so on. With this, is probate still involved?
That would pass by, let's see, it's a life insurance policy. So those pass by whoever you put as the beneficiary. But I've never seen that scenario where somebody just wrote by law. So I can't say whether or not it would go through a probate, but assuming that the wishes were that it goes by the laws of intestacy, it would go to the spouse first and then to the children thereafter. Then if there were no children, it would then keep going down the line and up the line, as they say, to that person's parents. And then if they're not around, then It could go to siblings and so forth. It could go, to distant cousins eventually. But yeah, the first one is always going to be the spouse, and then the children. And that's how it would go. But once again, you're under no requirements to write it like that. I would recommend putting a natural person if you're married currently, and then just changing it to whoever you'd want later on, rather than having the laws of intestacy or a court determine those things. And remember, each state has its own different nuances to those laws. So I'd always rather put, people there that I know will get it without any hassle. Because you also got to put yourself in the shoes of the people after you pass away. They're going to be the ones having to file these forms with the insurance companies and so forth, and you want to make it as easy as on them as possible. So don't know the exact answer to that one. That's an interesting one, but I'd say it's generally better to put people that you know rather than just saying by law.
Okay, your next question comes from Anna Campbell. Can the sole beneficiary be the trustee also?
Can you hear me?
Yes.
Hello?
Did you hear the question?
No, the phone gone out a little bit there.
Okay, the question is from Anna Campbell, and the question is, can the sole beneficiary be the trustee also?
Can you make the sole beneficiary the trustee? Yes, you could. Typically the way it goes is you name yourself as a trustee, then you typically name the spouse as a successor trustee, and they could also be the major beneficiary. So there's usually nothing against that. It just depends on whatever your wishes are.
Okay, the next question comes from Deborah Winter. Is there probate involved in a living trust?
In a living trust. Yeah, it's kind of like what I said earlier. There's usually always a small probate, and typically, even when you have a trust, a living trust, and all your assets that you want to pass according to that are titled in the trust, then you typically always have to file a little bit of paperwork at the court. And the reason why is because they want to make sure that any debts that were owed by the deceased get paid. So there's always what they call a creditor's claim period. So it's usually you're never going to get away totally without having to go through a little bit of court process. So there's always a small probate issues out there. You just want to avoid the major ones. And attorneys will typically charge a percentage, that could be a couple of percentage, like 2 or 3, for doing a probate estate. So let's say you passed away and you were worth $1 million. Well, they might charge $20,000 to do what they call probate the estate, and that's when you don't have any trust. But if you have a trust where most of the assets are in that trust, and let's say the only thing that wasn't in there was clothing and so forth and some items at your home, and those would be part of the probate, but it would be a very small amount. So the most your heirs would be charged in that instance would probably be under a couple $1,000 for just filing some small forms or going through the creditor's period. Because you always want to clear that period, the creditor's period, because then nobody can come at you later and say, hey, well, this person owed this money and earlier, and if you start timing that period, they can never come back at you years later. So that's why it's important, and that's why typically you always have that small probate estate. Now, a lot of people, they don't ever file anything, because they had all their assets in bank accounts payable on death. They didn't have any debts when they passed away, and they had a trust and it named everything. So sometimes people never do file a probate, but it's always good to file a small one just to clear that creditor's period so that they can never come back and try to attach assets later on.
Okay. Adrian Koval has a two-part question. The first part of the question is, wouldn't the house follow, are you there?
Yes, I'm here.
Okay. His first part of the question is, wouldn't the house follow the same rule? If I die, the house stays with my wife or still goes through probate?
Well, it depends on how the house is titled. If it's titled in husband and wife, joint tenancy, or so forth, then it would go to that spouse automatically because of how it's titled. If you pass away and it's just in your name, then typically that would be going through probate, where the spouse that is named after the first one passes away, if they wanted to have it titled in their name, they would have to produce death certificates and so forth.
Okay. Okay, so it goes through a process. And then he had a second part, and I believe you just answered that one now, but I'll read it off. There was a second part to the law insurance question. Wouldn't a house follow the same rule? It goes down the line. So if there is no trust or will, then a probate would be involved, correct?
Yes, it's just like if, say you're a single person, or if you're married, one spouse passes away before the other, which is typical. So then, let's say the wife is the longer living spouse. So the property is in her name by itself. She has a will, then it will go through a probate, and it will go to whoever she names in the will. If she doesn't have a will, it'll go by those laws of intestacy, and it'll go to whoever's down the line. If she set up a trust, it would go outside of probate. It would just go, she would have a trustee that would then basically title it in the name of the new owner, and that would go outside of probate. So those are kind of the three scenarios. If it was just in her name, she was the last one of the marriage left, and she died, as a single person at death, then it would go according to the will, through probate, of course, to say her daughter or something like that. So the daughter would have to, go through probate and get the house titled in her name. If it's in a trust, then whoever the trustee is would just file some documents down at the court, and it would be over and done with relatively quickly because it's in the trust. If there's neither, then it would go by the laws of intestacy, and say there was a daughter or multiple daughters around, then they would all, get together, hire an attorney, say, hey, she had no will. We're going to go by the laws of intestacy, and if there's 3 daughters or 3 sons or a mixture of both, then they would each get one representative share of that house. And then typically the house would be sold, and then they would each get their share, say an equal share, because there was no will. So that's how it would go down the line in that example, where you had husband and wife, husband passes away first, wife passes away second, and they have, say, 3 kids. Each will get a third, a third, and a third in the event that there was no will. Now, if they named a will, if they had a will prepared, they could say, we want it all to go to this one daughter, and then that one daughter would go through probate and then get the house. If they had a trust, if the woman had a trust set up, then it would pass along according to her trust, and it would be a much easier process because you just have to file a new deed, and that's all it would take. So, also some people they while they're alive, they add other people to the title of the home, so that then when they pass away, the other people automatically get it, avoiding probate, avoiding trusts, avoiding anything. But they add them to the title while they're alive. So there's actually about 4 ways that a house can transfer, through probate, intestacy, a trust, or through titling while you're alive.
Thank you, Richard. The next question comes from Rosendo Gomez. What do you think of do-it-yourself living trusts, such as LegalZoom?
It's I wouldn't recommend them because when you're talking about an important thing like creating your last will and testament of your trust, I always think it's better to have a little bit of face-to-face time. It might cost a little bit more, and I know at LegalZoom they do have extra features which you pay for, where you get somebody on a phone call or something like that. But unless you're doing something really, really simple, then it's always better to get an attorney that you can talk with face-to-face, that you can review the documents with, and you could feel comfortable with, rather than just, going online, logging in, and completing a couple of forms, and then they automatically spit out a trust for you or a will. I always think it's better to have a little bit of customization there. And also, sometimes you have people that, they don't know what would be best for them. So we've gone over some scenarios where special needs trust for children with special needs. We've gone over the Q-tip trust for you have a blended family. I'm not sure if LegalZoom asks all those questions. They might. You never know. I haven't gone through and used all of that. I've gone on their site and taken a look. But I always think it's better to have a little bit of face-to-face with a local attorney, because then you can introduce your family to them if you want. Then they have somebody local. If you write it on LegalZoom, you still, when you go to probate it afterwards, you still got to find somebody, locally. There's no LegalZoom for probate as far as I know. So they can draft the documents, but taking care of you afterwards, or taking care of your family members afterwards, probably not so much. So I always think it's better to have a live face-to-face situation where you can build a relationship, and over time, I think that's better.
Okay, we have time for a few more questions. This question comes from Mike Melton.
Sure.
And the question is, should or could there be two trusts for a married person, with one covering property held as separate for commonly held assets?
There can be multiple trusts, but you got to be careful about how you title them. Like, people have an IRA trust that just covers the IRA, and they might have a living trust, which could cover everything else, excluding the IRA. And they might have a life insurance trust, which they call an irrevocable life insurance trust. And that might be something that they set up to provide for their children when they pass away. That's why they call it a life insurance trust. So they purchase life insurance on themselves. They transfer the ownership of that insurance to a trust. And then when they pass away, the life insurance pays that trust, and it goes outside of their estate. So that's just an example where somebody could have an IRA trust, they could have a living trust, they could have an irrevocable life insurance trust. There's three right there. So yeah, you could have different ones, but you got to be careful that they don't overlap each other either.
Okay, your next question comes from Kenneth Felipe. Does the attorney retain a copy of the will or trust at his office?
Yes, they're always supposed to retain copies, so that, in case somebody, were to lose it or so forth, or that they just have a copy so that when the heirs contact them, they know what's going on. And oftentimes you also have situations where somebody passes away and they might not be able to find it at the house for some reason or another. Then they find the copy that is with the attorney, and then that would be the one that they find. So yeah, every attorney is supposed to keep copies of what they prepare, and they should have that, but you should also keep yours in a safe place and make it generally easy for people to find in the event that you pass away. So that's always what I tell people: keep it in a safe place.
Okay. We have time for a couple more questions, and then after that,
Sure.
we'll be providing our members with additional information on how the referrals we have here to be able to help you at the Los Angeles Police Federal Credit Union. And also, I'll be sending out a survey within the next day that will give you also the opportunity for you to put down additional questions and concerns that you would like someone to give you a call back on. So the next question comes from James Effort, and his question is, if I have a trust, do I still need a will?
Well, as I said earlier, you always need that pour-over will, because there's always going to be some assets that you can't put in a trust or that you forget to put in the trust. So typically the attorneys will prepare a pour-over will. That's like what we call it in the legal profession. It'll say last will and testament, and it'll say you want to leave, say, jewelry or something like that to a particular person, and then it'll say the rest and residue and remainder I want to leave to my trust, and that's what it would say there. So everything pours over to the trust. So most people that if they have a trust, they probably have that pour-over will, and it's probably in that same package of documents. That's where they have their trust. Very rare that an attorney wouldn't prepare the pour-over trust at the same time.
Okay, your next question comes from Tracy Gray. Do you have to register a trust with the LA County Recorder's Office? I purchased my home in the trust's name.
If you purchased a home in the trust name, it would be on deed. So that would be at the recording office because property records are public. The trust itself would not be there. That's the whole idea of having a trust, is that you have a measure of privacy. So what typically happens, the only thing that you would record would be a notice of trust, and that's like the first page and then the signature page just to say that a trust existed, but it wouldn't show the contents of the trust. And that would only be filed with the court at the death of somebody. So would not have an entire trust recorded at the county recording office. And when your house is owned in the trust, it just says on the deed that the house is owned by the trust without actually putting the trust, behind that first page. So it would just be on the deed that the ownership of this house is held in the, Richard DiNapoli Irrevocable Living Trust, and that's what it would say. It wouldn't tell you anything more than that.
Okay, last question, Richard. This question comes from Janet Mullen, and her question is, we are domestic partners, no will or trust yet. We are both on title of our house and vacation home, etc. Do we need the security of a trust or will, or by California law, are we okay and net headed to the probate situation if one of us dies?
Well, that's a tough question right now. We have 37 states as of today that that have ruled in favor of same-sex marriage and so forth. So as long as you stay within those states, and I know California is one of them, then they would respect all of that. And if your name is titled on the actual house and the property, then it doesn't matter whether you're partners or not. It always goes according to what's titled. So let's say you have partners that are partner number 1 and partner number 2 as joint owners on a property. Well, it doesn't matter if they're legal spouses or not. They're still jointly named on that property. So it could be 2 unrelated people even. It'll always go by operation of law to the other person if they say joint tenants with right of survivorship. Then it'll just go to the next person after the first one passes away. So that's one of the key things to remember, is that when you name somebody on a bank account and you name them as a joint owner, then they get it when one passes away. That's it. And that goes outside of the will, outside of a trust, outside of anything. That's what they mean by operation of law. It's just the law. It's their joint owners, and that's the way it goes. And the same thing if you have multiple people on a deed as joint owners with rights of survivorship. And it doesn't matter if they're related, if they're husband and wife or anything, they're recorded as joint owners. So when one passes away, the other one just gets it automatically. And so that goes for bank accounts, that goes for houses, and those are the two primary items of how assets are titled where they pass automatically. So just naming people on the house, that's great.
Okay, at this time, Richard, if you can forward the slide to the next. And I would like to provide you all with your referral resources here at the credit union. Our contacts here at LAPFCU are Christine Manazian and Nick Chow. They are our will and trust coordinators here, and they can be contacted at 1-877-695-2732. Again, that number is 877-695-2732. In addition, this webinar has been recorded, and I will also send out a survey to you within the next couple of days for you to be able to let us know your thoughts on how the presentation went, some future presentations that you would like to see, any of your questions, comments, feedbacks, and then you'll also be able to let us know if you would like someone to call you back regarding a specific question that we were unable to get to, or just because you want to talk to someone. Okay, and at this time I would like to say thank you very much for joining our webinar tonight. Have a nice evening, and we will look forward to seeing you in future webinars.
Thank you very much.
Thank you. And